Ready? Start. The appellant, being a probationer, has rightly been discharged from service, and the writ petition has rightly been dismissed by the High Court for valid reasons, and judgment of the High Court does not call for any interference. The bare reading of the above impugned notification shows that it is ex facie, not stigmatic. It simply discharges the appellant from service as having been found unsuitable to hold the post of district judge until and unless the appellant is able to show circumstances supported by cogent material on record that this order is stigmatic and is intended to overreach the process of law provided under the rules. There is no occasion for this court to interfere on facts. As far as law is concerned, the question raised is with regard to the applicability of the concept of deemed confirmation to the present case under the service jurisprudence. We may also notice that conduct of the appellant, who is a judicial officer belonging to the higher judicial services of the state, is matter of some concern. Contradictory statements have been made in the writ petition before the High Court, memorandum of appeal before this court, and even in the rejoinder and further affidavit filed before this court. Strangely, the High Court has neither contested this case nor pursued it in its correct perspective. As it appears, even appearance on behalf of the High Court was not entered upon. Despite specific orders of this court, the High Court had failed to produce the records, and even no responsible officer was present. Mr. R.N. Sharma, learned senior counsel, appearing on behalf of the appellant, submitted that a statutory right of protected tenancy is not lost on account of delay or lashes. It was submitted that such a right is not obliterated for want of application, particularly when the law does not contemplate any such application by the person claiming to be a protected tenant, and also in the absence of any injury or prejudice to the landholders. In this connection, it was urged that under Section 37A of the Act, a tenant in possession becomes a protected tenant, and the said section directs the authorities to record him as a protected tenant, and that section does not prescribe any application to be made, and therefore in such circumstances it cannot be said that a statutory right is lost because the concerned person did not make any application for recognition of his status as a protected tenant. In other words, it was urged that if a tenant is in possession, then the statute confers upon him the status of a protected tenant, and such a right continues even if the person entitled thereto fails to move the authorities for grant of a declaration. In the circumstances, it is urged that the appellant was entitled to a certificate of ownership under Section 38 of the Act. It was next urged that delay or omission if any, to compile list of protected tenants under section 37 and 38 of the Act was on account of the failure on the part of the concerned authorities under the Act, for which the tenant cannot be denied as status of protected tenancy by invoking the theory of laches and delay. Learned Counsel urged that the statutory rights of the protected tenant conferred up under Section 37A upon cultivating tenants in possession are automatic and not dependent on applications to be made. He acquires rights of ownership under Section 38 of the Act automatically. The respondents were patter of lands and measuring 2,000 acres, which was more than the ceiling prescribed, and therefore Sham Lal had acquired rights of protected tenancy under Section 37A of the Act because he was the cultivating tenant in possession. Learned Counsel urged that the name of Sham Lal was recorded in the Khasra for the year 1954 to 55 as a tenant, and his name was shown as a pattedar subsequently, and therefore it was the statutory duty of the tribunal to conduct an inquiry suo motu, which they failed to do. It is the case of the appellant that they are in possession of the land throughout, and they moved under the Act only when their possession sought to be disturbed. Learned Counsel submitted that it was a duty of the concerned authorities to prepare a list of protected tenants. They failed to prepare the list, therefore, according to the Learned Counsel, the application of the appellant under Section 38 ought not to have been rejected on the ground of delay and laches. In our view, it is not necessary for us to express any considered opinion on the question as to whether, in view of the provisions of Section 18 of the Andhra Pradesh Tenancy Act, the suit before the district munsif was maintainable. Source is 3P Legal, RSC, exercise number is 33, and words are 799, and speed is 100.